So, keeping in mind the judge's advice, let's go through the basics of preparing for the hearing. First, you need to be clear about what legal issues the judge is being asked to decide. Is it the amount of child support? Or maybe it's how you will divide your marital debts or your marital property. Make an outline for yourself, listing the relevant issues and your position on each issue. During each step of preparation, stay focused on those issues. Second, for each issue, list the facts the judge will need to consider. Third, decide how you will be able to present each of those facts to the judge as admissible evidence. The term evidence includes all of your statements under oath, any witnesses' testimony in court, and any documents you offer. So for each of these types of evidence, you need to ask two basic questions. First, is it relevant? That is, will the information help the judge understand what he or she needs to know in order to make a fair decision? Second, is it admissible? This means, is it reliable enough for the judge to consider it? The main rules of evidence are very complicated, but basically the rules try to encourage the use of reliable information and keep out unreliable information. In addition to relevance, here are two other basic rules. Evidence must be authentic. In other words, the judge needs to be convinced that a document is what you say it is. This is called laying the foundation for the evidence. If the document is a record that you kept yourself, you may be able to authenticate it by your own testimony. However, documents like hospital records must either be offered into evidence in court by a person who is the creator or keeper of those records, or they need to be authenticated by such a person. Police reports are specifically not admissible. If you want that information in the record, you must subpoena the involved officer to testify. Next, a statement, whether written or oral, cannot be hearsay. Generally, this means that you cannot rely on out-of-court statements. We'll explain more about the hearsay rules in just a minute. Let's take a closer look at the first question. Is it relevant? All evidence must be relevant to a live issue in the case, or the judge won't listen to it. By live issue, we mean something that the judge still has to decide, as opposed to something that's been agreed to, or an old complaint you have about your spouse that doesn't have anything to do with a currently disputed issue. Even if something is technically relevant, a judge can still decide not to admit the evidence if it is repetitive, or if it's so inflammatory that its unfair prejudice outweighs its useful relevance. Here's an example.
I saw him check into a motel room with Susie, his new girlfriend.
Objection.
Grounds?
Relevance. I've already agreed that we had irreconcilable differences, so what either of us did before is not relevant.
Ma'am, where are you going with this?
Judge, he's an adulterer and I want alimony for it.
Maine law says that alimony is not tied to the issue of fault. There's already plenty of evidence that this marriage is totally broken down, so I'm not going to allow this line of testimony. Objection sustained.
Obviously, John's adultery is an important issue for Judy, but the judge needs to focus on the legal factors that are relevant to his determination of spousal support, such as the parties' finances, their ages, and the length of the marriage. To be successful in court, Judy needs to focus on the same issues and relevant facts. Most people instinctively understand the concept of relevance, but many get confused by the next topic, the hearsay rules.